Hey, this is Adam Garner, Philadelphia ERISA attorney. I'm sitting here in my freezing cold office, and I was thinking about some of the work we've done in the last week. And one of the things we did was an appeal on a Top Hat pension plan. The reason a Top Hat plan is interesting is because it is exempt from many of ERISA's requirements, including its fiduciary requirements. Another interesting feature about Top Hat plans is that the amounts that have been set aside for retirees under the plan are not segregated from the employer's general assets. With a normal retirement plan, like a traditional pension or a 401k plan, the funds are held in a separate trust and they're protected from the claims of the company's creditors. With a Top Hat plan, the assets of the plan have to be subject to the claims of the company's creditors. Sometimes employers will create something called a rabbi trust to put the money in a segregated account so that those individuals who participate in the Top Hat plan are aware that the money has been set aside for them, but it still doesn't protect the money from the claims of the creditors. One feature of Top Hat plans that administrators are required to comply with is ERISA's claims process. So if a claim under a Top Hat plan is denied, you have the same right to appeal as you would under any other retirement plan, and the administrator has to meet the timelines and the disclosure requirements set forth in ERISA's claims regulations for a Top Hat plan claim. Top Hat plans are pretty rare, so unless you are making a lot of money at a company and you're a fairly senior executive, you probably don't have one. But if you do have various types of retirement benefits at your employers, you may have a Top Hat plan if it's called a non-qualified plan or if it's referred to as a supplemental executive retirement plan. Those are often two terms that are used to describe a Top Hat plan. One of the things that's interesting about our firm is we actually have litigated Top Hat plan claims to judgment, which is not particularly common. For a variety of reasons, one of which being there aren't that many people with Top Hat plans to make claims, but the other is very few claims get to judgment. We had a case several years ago that we not only took past the summary judgment stage, which is where most ERISA benefit claims get resolved, but we actually had a 2-day trial with multiple witnesses and prevailed in that case, and then we won the case at the United States Court of Appeals. So if you have a Top Hat plan and you're having issues with it, you can feel free to give us a call and we'll see if we might be able to help you. Thanks. And if you have any questions, please leave a message in the comments. Thanks. Look forward to hearing from you.